Once again, welcome to the Employee Benefits and Executive Compensation Fall broadcast. Today's presenters are Greg Dugg, Casey Fleming, and Marion Dodson. Questions can be entered via the Q&A widget open on the left-hand side of your screen. We will address questions at the end of the program via email or via phone call if time is permitting. If you experience technical difficulties during the presentation, please visit the webcast help guide by clicking on the help button below the presentation window, which is designated with the question mark icon. The PowerPoint presentation will be available on our website at foley.com in the next few days, or you can get a copy of the slides in the resource list widget. Foley will apply for CLE credit after the program. To be eligible for CLE, you will need to log into the On24 session and answer a polling question during the program. If you did not supply your CLE information upon registration, please email it to hpapadakis@foley.com. Please note certificates of attendance will be distributed to eligible participants approximately 8 weeks after the web conference via email. Note, those seeking Kansas, New York, and New Jersey CLE credit are required to complete the attorney affirmation form in addition to answering the polling question that will appear during the program. A 5-digit code will be announced during the presentation. Email the code and the form to hpapadakis@foley.com immediately following the program. And once again, questions can be entered via the Q&A widget, and those questions will be answered after the program via email or via a personal phone call. What we intend to cover today: benefit claims by non-employees, the issues that won't go away, severance agreement tax traps and solutions, and how to use carefully crafted health plan provisions to reduce HR headaches. At this time, I'll pass it off to Greg.
Thank you. Good afternoon or good morning to those in the Mountain or Pacific time zones. In today's first segment, we're going to take a step back in time to review a topic, benefit claims by non-employees, that isn't particularly new, but that one might say never goes out of style. The discussion topic is whether workers who a company believes to be non-employees, contractors, might be able to claim that they are entitled to the benefits that the company provides to its employees. Because that topic continues to be relevant, we wanted to visit, or should we say revisit, the issue in our discussion today. By way of background, companies might receive services from 2 categories of workers. Category number 1 would be workers who are classified by the company as employees. The workers are paid through company payroll and receive a Form W-2 every January. The company withholds and remits income and FICA taxes, with the company paying 1/2 of the FICA and Medicare taxes. And the workers are eligible for employer-sponsored benefit plans such as medical, 401k with company match, and so on. On the other hand, there are workers who are classified by the company as non-employee contractors. These workers are paid by the company through accounts payable or via a third-party agency. If they are paid by the company through accounts payable, they receive a 1099 tax form rather than a W-2 at year-end. If they are paid by a third-party agency, they receive a W-2 from the agency. The workers are ineligible for company-sponsored benefit plans, although if the workers are paid through an agency, there might be agency-sponsored benefit plans. So from the starting point of there being 2 basic categories of workers, what are the legal issues? Where do the potential disagreements, the potential fights, the potential challenges, where do they arise? Challenge number 1, or potential challenge number 1, the workers claim that they have been misclassified, that although they have been classified as fitting under Category 2, non-employees, they are in fact employees, and as employees, they are entitled to 401k benefits, company match, medical, or whatever else is provided or made available to employees of the company. This is the type of challenge that we generally think of. But challenges might arise in other situations as well. For example, a second type of challenge might be the IRS challenging the classification, seeking income and payroll taxes from the employer. Or the IRS might challenge the classification for some other purpose, such as the Affordable Care Act rules that, as currently in effect, and if they were to be enforced, require large employers to offer health benefit coverage to at least 95% of its full-time employees. Obviously, if a company has a large number of workers who are classified as non-employees and who are not receiving insurance coverage, one could envision a potential question of whether the non-employees really are employees and whether the company really is in compliance with the 95% rule. The details of the ACA rule and how it applies is beyond the scope of today's discussion, but the point is relatively straightforward that there may be instances in which the government has an interest in claiming that workers who have been classified as non-employees really are employees. Finally, there could be issues with respect to other benefits such as workers' compensation insurance coverage. If a worker sustains an injury on the company's premises, there may well be an argument that the worker is an employee for workers' compensation purposes. The workers' compensation system doesn't necessarily accept how the company classifies a worker. So potential workers' compensation issues are one more question that should always be addressed when thinking about employee classification issues. The larger point, of course, is that whether it's item 1, item 2, or item 3, employee classification issues can arise in a variety of contexts and remain very relevant. I mentioned at the opening of the presentation that this is an issue that never loses its relevance. The proof of that statement can be seen in a case that's now working its way through the courts. In that case, an insurance company has classified certain insurance agents, its sales force, as non-employees. In my understanding, this is a common classification within the industry. However, the agents have claimed that they are employees on the rationale that they are not really independent and that the insurance company exercises substantial control over how they do their jobs. Many times, the issue is that a person who is classified as a non-employee claims to be an employee in order to seek eligibility for benefits. This new case involving the insurance company is a little bit different in that the issue is not eligibility for benefits, but rather the funding or the security of retirement benefits. Under the benefit programs in place at the insurance company, the agents earn certain retirement benefits, which the company pays out of general corporate assets as they become due. But if the agents are really employees rather than contractors, then ERISA would say that the company should be setting aside the retirement money into a trust so that it wouldn't be lost in the event that the company were to ever become insolvent. If the insurance company were required to write a check today to pre-fund the benefit, to put the money into a trust, there are reports that the amount needed would be $675 million. So the amount at stake is substantial, and again, proof that these cases keep recurring and recurring. In the new case, in the insurance company case, the district court determined that the agents were employees because the company exercised day-to-day control over how the agents do their jobs. The case is now on appeal, and the insurance company might win. However, for our purposes today, it doesn't really matter who ultimately wins. What is important for us is that here is a case in 2017, a new current case, in which there are potentially dramatic consequences based on whether a worker is providing services as an employee or as a non-employee. Now, if the current insurance company case that is working its way through the court system sounds familiar, it should. Back in 1997, in a case involving Microsoft Corporation, individuals known as freelancers were classified as independent contractors. The IRS determined that the freelancers were really employees such that Microsoft should have been withholding taxes and should have been paying the employer share of FICA and Medicare taxes. Following the IRS determination, Microsoft reclassified the freelancers to employee status, prospectively effective, but the freelancers argued for retroactive benefits, claiming that they were always employees and should have received, not only prospectively but for past periods as well, the benefits provided to employees. Those benefits included certain stock rights or the ability to buy Microsoft stock at a discount. And as some of you undoubtedly remember, Microsoft stock was a hot commodity at that point in time. So that was the issue in Microsoft way back in 1997, and we now have the insurance company case that is working its way through the court system. Two cases, 20 years apart, dealing with the same basic issue of whether a worker or class of workers is an employee or a non-employee. 20 years of fighting over the same issue. So if we step back and we say, why has this been going on for 20 years? Why has this taken 20 years? First, of course, is the amount of money or value at stake in any given case. It's significant, and as long as the value is significant, questions will continue to be raised. In the insurance company case that we just talked about, we said that the potential cost, if there's a need to write an immediate check to a trust fund, was $675 million. In other cases, where the issue is the worker's eligibility for benefits, I don't have to tell any of you about the cost or value of those benefits. Employee benefits routinely are a third, 40%, sometimes more of an individual's base wage. So there's a lot at stake, and when there's a lot at stake, issues will come up. But beyond that core economic point, I think that there's often another reason, namely that companies lose track of the fact that this is actually a legal issue, not just a business decision for the company to make in its discretion. And this is the key point. The manner in which parties view and characterize their relationship, whether they view it as an employer-employee relationship or whether the parties view their relationship as one of service recipient and independent contractor, that's relevant, and I don't want to suggest otherwise, but it is not the end of the inquiry. From a legal perspective, a worker does not become a non-employee contractor simply because the company classifies the worker as a non-employee. From a legal perspective, the test is much more than the label. Officially, from a legal perspective, the existence of an employer-employee relationship is determined based on all of the facts and circumstances of each case. And the IRS has published a 20-factor test that looks at a variety of facts and circumstances, including whether the worker has other clients beyond the company, which is indicative of contractor relationship if there actually are multiple clients, whether the worker supplies his or her own tools, again, if the contractor or if the worker supplies his or her own tools indicative of contractor status, and various other factors. But when you boil it all down, the essential issue is whether the company exercises authority and control over how the worker does his or her job. For example, the manner in which the worker does the job, where the worker does the job, the hours at which the worker is present or available to do the job, and so on. Control over not only what the job is, but how it is done, where it is done, and over what period it is done are the essential hallmarks of an employment relationship. And this highlights an inherent tension. In many cases, the company really does want to control how the job is done. The worker is expected to be present at the employer's offices during normal business hours. The worker is expected to follow certain rules and procedures when performing services, and so on. But all of those factors, all of that control, the ability to direct the employee or direct the worker as to how the job is done, those all suggest employee status because the company really wants the control, even though it might also wish to qualify the worker as a non-employee. Thus, there is an inherent tension that is present in these types of arrangements. The company really, in many cases, wants it both ways. So after 20 years, what does that all mean? What action steps should we be taking? First, be certain that formal benefit plan documents extend eligibility only to workers that the company classifies as employees. This is designed to eliminate retroactive benefit coverage. If the benefit plan simply says that it covers company employees and the worker then is successful on a claim that he or she has been misclassified, the worker likely will be eligible for benefits for the entire period, not only prospectively, but retroactively as well. On the other hand, if the benefit plan limits coverage to those workers whom the company classifies as employees, then benefit plan coverage should be prospective only. That is, if the worker proves that he or she is an employee and the company prospectively reclassifies the worker, benefit coverage should also be prospective only. The point here is that even if the company's classification of the worker as a contractor, as a non-employee contractor, turns out to be incorrect and is subsequently changed, either because a court required the change or the IRS reclassified the employee, the benefit coverage should be prospective only because the benefit plan eligibility is not dependent upon actual employment status, but rather is being dependent upon how the employee is classified by the company. And so the benefit plan coverage only extends to periods of time that the individual is classified as an employee, and therefore should only extend to periods from and after the date on the reclassification. To some extent, of course, this is old hat. Almost all pension or 401k plans have language to this effect. But we still see some welfare benefit plans that do not. We think the reason for this is because pension and 401k plans typically have a very formal, detailed plan document that has the requisite language. For welfare plans, however, the documents might be looser, less precisely defined, less precisely drafted, and might change more frequently as companies move from one vendor to another. So even after 20 years, welfare plans might still be a concern. So, first to do is to check all benefit plan documents to make certain that they really do include the appropriate language. They should, but we find that not all do. Second, scrutinize long-term non-employee relationships and raise questions if appropriate. I am not suggesting that every person who is a non-employee or who is classified as a non-employee should be reclassified as an employee. For example, in the modern business world, companies sometimes outsource certain functions to other companies, and I am not suggesting that all of the employees of the outsourcing company are or should be classified as your employees. However, if there are cases where a worker is providing services as a non-employee and the worker or workers are doing jobs that are also being done by employees, they might be sitting side by side with employees, and if the workers have done these jobs for multiple years at the company facility, working prescribed hours, taking the same directions as employees, consider those situations. Because if you look at those types of situations, and if it's difficult to distinguish between those jobs that are classified as non-employee jobs and those jobs that are classified as employee jobs, then perhaps there's an issue. And if you have trouble distinguishing between the employee jobs and the non-contractor jobs, you know that the IRS, if it were to look at the issue from a tax perspective, would conclude that the workers are employees. Third, and finally, even though we have focused today on non-employee claims for benefits, consider other areas where there might be negative consequences if the workers are misclassified. We mentioned the Affordable Care Act earlier in the discussion, and I'll return to it now for just a minute to complete the thought. As you know, the ACA might be described as being in a state of flux, and there were various efforts recently to repeal the law, which failed. And while the law is still in effect, certain parts of it are not being enforced or penalties are being waived, so there's a lot that still needs to be worked out. However, if we just look at the law and the regulations as published, one of the requirements that we mentioned before was that an employer must offer coverage to at least 95% of its full-time employees. If there are full-time workers who are classified as non-employees but who really are or might be employees, then that obviously could affect whether the 95% test is satisfied. So there's always a need for vigilance in monitoring how workers are classified. If the classification is incorrect, there could be significant consequences, whether those consequences come in the form of a benefit claim seeking plan benefit coverage, or whether the consequence involves the question of whether the company has in fact complied with laws such as the Affordable Care Act or its 401k non-discrimination rules or other similar requirements. And this is why, although the issue isn't new, the question the question of whether someone is an employee or a non-employee is as relevant as it ever was. And with that, I will turn the presentation over to Casey Fleming. Casey?
Thank you, Greg. As we have mentioned, I will be discussing some of the trickier and sometimes counterintuitive tax issues that we run into when we are drafting and reviewing severance agreements. Now, this material may sound somewhat familiar to some of you because it is based on a post that we contributed to our employment colleagues' fantastic blog earlier this year. But we got enough positive comments about the blog post and requests for additional information that we thought it would be worth addressing in more detail today. I wanted to start out by setting the stage a bit for our discussion. For the most part, these issues, or tax traps, arise when employers are drafting new form severance agreements or negotiating executive severance packages. As we will discuss, one of the important issues to understand in either context is whether the employee is already party to an existing contract. For example, an executive employment agreement that also addresses severance. Although employers, especially in the United States, tend to think that benefits that have not yet been earned may be changed prospectively, we will cover why this is not always true if you do not want to run into certain tax traps. Tax trap number one, giving the employees a choice between receiving their severance as a lump sum payment or in the form of installments. Some employers have very strong preferences regarding how to pay severance. Some prefer to pay severance in a lump sum soon after an employee terminates. For example, because they want to be done with the administration as soon as they can, or to take their deduction as soon as possible. While other employers prefer to pay severance in a series of installments, say for a year or two following the employee's termination of employment. For instance, because they want to be able to use severance to help with enforcement of a non-compete covenant or address a COBRA withholding issue that I will discuss a bit later. But some employers do come to us and say, we drafted this agreement to allow the employee to choose whether to receive their year of severance in the form of a lump sum payment or over the course of 12 months following their termination. We don't care either way, so we just wanted to provide them with the maximum flexibility possible. The second scenario we run into is a slight variation on the first, but instead of building flexibility into the agreement itself, the employer wants to accommodate a particular executive. For example, imagine that one of your executives has an existing employment agreement that provides for $1 million of severance payable as a lump sum in qualifying circumstances. That executive is leaving under very good terms, and in connection with the negotiation of the severance package, she approaches you and asks that the severance be provided in the form of installment payments over the course of a year instead of as a lump sum, and you want to accommodate that request. While both of those approaches are admirable from an employee relations standpoint, they may cause some unintended tax consequences. First, what we refer to as constructive receipt. As you might imagine, The IRS is highly motivated to come up with reasons to insist that individuals pay taxes sooner rather than later. They want their money now. So when employers give employees a choice between money now or money later, the IRS takes the position that the full amount is taxable in the first year that the employee could have received those funds, regardless of when or how the severance is actually paid. They essentially treat it as having been paid in that first year. On the flip side, almost no employee will choose to push payments into installments if they have to pay all of the tax that they owe immediately, even for payments in later years. In order to avoid this issue, it's best either to commit to one approach, lump sum, or the other, installments, or at the very least to avoid explicitly outlining that choice in the severance documents. For our second executive, the woman who is entitled to lump sum severance but asked to push it out into installments, likely to delay the tax impact of those payments, there is also a potential issue under Code Section 409A, which is a provision in the Internal Revenue Code that puts limits on when and how employers and employees may change the time and form of payment of certain deferred compensation. While certain exemptions may apply, especially in the severance context, and I'll discuss those at a very high level next, if they don't, and the timing of the payments are shifted from one calendar year to another, then the executive is also subject to an additional 20% income tax in that first year under Code Section 409A. In my example, the severance was not exempt under the severance pay exemption because it exceeded 2 times the current Code Section 401A17 limit. Don't panic, I'm going to talk about the exemptions momentarily. But as a result, because the payment would have otherwise been made as a lump sum under the terms of her employment agreement and was then pushed out into non-exempt installments, the executive must be taxed in year 1, even though the installments extend into year 2 under the constructive receipt rule, and will also be subject to an additional 20% income tax as a result of the 409A violation. While the most significant impact of these tax traps are felt by employees, employers are also at some risk for failing to correctly report and withhold, but also for some potentially serious employee or executive relations issues. Which means that the moral of this story is less flexibility with less tax is almost always better than more flexibility with more tax. As I mentioned, severance payable to most employees will be exempt from Code Section 409A under one of 2 exemptions, the short-term deferral exemption or the severance pay exemption. Under the short-term deferral exemption, severance will not be subject to 409A if it is paid in full prior to the later of March 15th or 2.5 months following the end of the employer's fiscal year, following the year in which the employee separates from service. So if I were to terminate today, then my severance would be exempt from 409A as a short-term deferral if it is fully paid to me by March 15th of 2018. Under the severance pay exemption, severance will not be subject to 409A if it's due following an involuntary separation, for example, a termination not for cause. It is no more than the lesser of 2 times the employee's base salary or the Code Section 401A17 limit on compensation, and that limit is currently $270,000, so 2 times that would be $540,000, and all of the severance is paid out by the end of the 2nd year following the year of separation from service. These exemptions are important to remember because subject to the constructive receipt rule, it is generally okay to modify the timing of exempt payments as long as they are exempt under either exemption before and after the modification. For example, it's generally okay to accelerate the payment of exempt severance pay. And I know this is going to sound like a plug, but there are so many other potential 409A issues that come up in the context of severance agreements, and sometimes they're very counterintuitive and unexpected. So this really is an area where it's always wise to consult with a benefits attorney. Tax trap number 2. The 3 scenarios I'm going to discuss next come up when employers try to get fancy with COBRA benefits in connection with severance negotiations. This first scenario comes up for us on a fairly regular basis. Here, an employer has decided to supplement the cost of COBRA benefits so that the coverage during the severance period is quote-unquote free, or so that the individual is not paying more than the active employees are for a certain period of time following their termination. The problem with this fairly common approach is that if this coverage is only offered to executives and not the general employee population in similar circumstances, then the coverage will likely be considered discriminatory, which in our employee benefits world generally means more generous to highly paid than non-highly paid people. And that discrimination may have tax consequences. As the rules stand today, the impact of the discrimination will depend on how the medical plan is funded. If the plan in our example is self-funded, or what we sometimes refer to as self-insured, and the coverage is discriminatory, then that executive should be taxed on the value of the supplemented coverage in the year that it's provided. This means that the benefit is subject to withholding and must be reported on a W-2, not a 1099. To add insult to injury, the employer may also run into a withholding issue in these circumstances if there are no other ongoing cash payments to the executive during the period that these COBRA benefits are provided. For example, if the executive received a lump sum severance payment immediately after terminating, but receives quote-unquote free COBRA each month for 12 months, and the value of that benefit must be taxed, then it will also be subject to a withholding obligation. However, because there are no ongoing cash payments to withhold from, the executive is either going to have to write a check each month to cover the withholding, or the free COBRA must be structured as a reimbursement from which withholding could potentially be taken unless the employer agrees to a gross up, which we'll discuss later. As you can imagine, this can turn into a giant headache. So that's our self-insured plans. If the plan is fully insured, then there are currently no consequences of providing this type of discriminatory coverage. However, there are proposed rules that are currently in regulatory limbo that would subject fully insured plans to similar non-discrimination rules, but with much more serious consequences to the employer. If these rules go into effect, then the employer, not the employee, will be subject to a $100 per day excise tax for each day this type of discriminatory coverage is provided, and that can add up very quickly. Of course, we don't know if these rules will ever go into effect, especially in the current political climate, so some employers are taking the position that it's business as usual until they hear differently. Other, more conservative employers with fully insured plans are choosing to address this uncertainty by including language in their severance agreements, which provides that the COBRA benefit will stop or be replaced with a different benefit if the employer ever becomes subject to excise taxes as a result of the arrangement. COBRA tax trap number 2. So sometimes employers will come up to us and say, well, instead of messing with supplemented COBRA, let's just give them cash. In this scenario, the employer decides to just provide this cash benefit instead of dealing with offsetting the cost of COBRA coverage. If this benefit is tied directly to enrollment, for example, the employer requires proof of enrollment before paying a cash installment, then there is no problem with this arrangement as long as it does not otherwise violate the discrimination rules I discussed in connection with the prior slide. However, if the employer simply provides for a cash benefit, For example, a payment or series of payments equal to what COBRA would have cost the executive, but does not make it contingent on enrollment in the COBRA coverage, then the value of that benefit is taxable income to the employee regardless of whether or not the coverage itself is discriminatory. This means that this rule does apply to fully insured plans too. Practically speaking, the IRS is essentially saying that there is not a close enough connection between the medical benefits that may be provided tax-free under the Internal Revenue Code and the cash payment. So as a result, they simply treat it like a cash bonus or additional severance and tax it in the same way. Finally, though we don't see this as much, there are certain circumstances in which the COBRA benefit itself might become subject to that dreaded Code Section 409A. This happens if the benefit extends beyond the normal COBRA period, for example, 24 months rather than 18 in the example on this slide. When that happens, the benefit becomes subject to the restrictions on the changing the time or form of payment under 409A. So if the timing changes, in the example above, if the subsidized benefit that extends beyond the standard COBRA period is accelerated and cashed out, then that acceleration would violate Code Section 409A and the cash payment would be subject to an additional 20% income tax. This is just another reminder that it's a good idea to consult a benefits lawyer in the severance context because Code Section 409A can jump out at you when you least expect it. I'm not going to discuss this slide in too much detail, but I did want to provide everyone with a gross-up formula that you could use if you would like to gross up the benefit provided to executives in order to offset the adverse tax consequences of taxable health insurance benefits. In other words, if the benefit becomes subject to tax, for example, because it's discriminatory self-insured coverage, you can offset the effect this has on the executive by providing a gross-up. To use this formula, you will need the amount of the benefit, for example, the value of the COBRA premium for fully subsidized coverage, and the tax rate that will apply to the executive. Then you run those amounts through the formula to put the executive in the same position he or she would have been in from a tax perspective if the benefit had been non-taxable. I'd say that most employers do not volunteer to pay gross-ups, and for publicly traded employers, be aware that ISS hates them, but is still a nice tool for you to have in your executive compensation toolkit. Finally, just in case you did not get enough Code Section 409A for one afternoon, our third tax trap. You will run into this problem if the severance that you're paying is not exempt from 409A as either a short-term deferral or under the severance pay exemption, is subject to the execution of a release of claims, which is very common, and it is possible that the executive could control the calendar year in which the first installment payment is made, depending on when he executes the release. I think this one's easiest to understand with an example. So take an employee who's owed $1 million in severance, payable over 12 months, and the payment of the severance is conditioned on the execution of a non-revocable release. As you recall, the severance is not exempt from 409A because it will not be fully paid out within the short-term deferral period, and it's in excess of the severance pay limit. So the employee separates from service on December 15th, 2017. That employee is given 21 days to sign the release of claims. So if the employee signs the release on December 16th, the release will become irrevocable on December 24th, following the 7-day revocation period, and the first payment will be made with the last payroll in 2017. However, if the employee waits to sign the release until December 26th, then it will not become irrevocable until January 3rd, 2018, and the first installment payment will be paid with the first payroll in 2018. This violates Code Section 409A because the employee did have the ability, depending on when he chose to execute his release, to shift his payments from one tax year to the other. Luckily, this can be a simple fix. You can simply include language in your severance agreement that provides that the first installment payment will always be made in the second year if the release period spans 2 calendar years. Again, This only needs to be included if the severance pay is not exempt from 409A, but some employers include it in every agreement so they don't have to monitor the language depending on whether or not the severance they're paying is exempt. While this will generally only come up in practice for executives who are terminated in the last month of the year and receiving those non-exempt severance payments, I really would still consider including the 409A fail-safe language if there is even this chance that the severance could become subject to 409A. So that is all I have for today. So without further delay, I will turn the presentation over to Marion.
Thank you, Casey, and thank you, Greg. I'm Marion Dodson, and I specialize in helping employers with their self-funded health plans. Today, I'm going to talk about avoiding problems that can be created by your health plan. Specifically, I want to talk about provisions you can add to your summary plan descriptions and other employee communications that will reduce headaches for your human resource departments and decrease your legal costs. I'm going to start by talking about health plan enrollment and payroll deduction issues, and then move into ways to limit participants' rights to sue. Okay. So let's begin with newborn baby health plan enrollments, because this is an area you've all likely encountered. Your plan is required to allow newborns to be enrolled within the first 30 days, although there might be a longer period specified in your plan. Regardless, you need to know what your plan's deadline is, and you need to make sure that your new parents know. It's a crazy time after the birth of the baby, and enrolling in the health plan is probably not forefront in anyone's mind, especially since the first month baby doctor visits are automatically covered by your plan. Because of this, some parents might not even realize that their baby isn't automatically enrolled in the plan. So unless you want some really upset new parents, you need to get this information out there. There are several ways to accomplish this. First, when your plan is distributing its annual notices, you should add a large special enrollment period notice on the first page that says, important enrollment deadline. If you gain a new dependent, you must enroll that dependent within 30 days. This includes newborn babies, and the deadline applies even if you have family coverage. Then reference the page that has the complete notice. Another thing you can do is tell people when they leave for or ask about maternity leave. You can also follow up with people who are on leave. So many families fail to enroll their newborn in a timely fashion. They're overwhelmed, or they think that family coverage automatically covers their baby. Get this information out there. It should not be a surprise to anyone. And another thing you can do is amend your plan to allow a slightly longer enrollment period for new dependents, for example, 60 days. But if you do this, make sure you tell your stop-loss carrier first. Now I'm going to quickly give you some specific language to put in your health plan documents to deal with the issue Greg discussed. That is the problem of independent contractors who are miscategorized as employees. I'm going to talk to you about, and I'm also going to talk to you about enrolling these people in your health plan. So you've already heard from Greg that you should be very careful when categorizing employees. So let's just skip to you tried hard, but unfortunately someone was miscategorized. You need language in your plan that clearly states that such individuals do not have any health plan rights. For example, in your health plan SPD definition section, you can specifically define the term employee as a common law employee determined solely from the payroll records of the employer. Also, specifically say that if an individual is classified by the employer as an independent contractor, such individual will not be treated as an employee for purposes of the plan until they are so categorized by the employer's payroll. And say that the employee will not be treated as a participant in the plan until the employee actually enrolls in the health plan. And that this applies even if a court or administrative agency later determines that the individual was a common law employee. And as for the newly classified employees, you should enroll them and their dependents and start covering them going forward. Now I need to break briefly to give you your CLE information. At this time, I'm going to read the CLE code for this program. If you are in need of CLE credit today, please enter this 5-character code into the poll question on the screen after it is announced and press the submit button. The code is YWRV8. Again, that's YWRV8. Again, if you're seeking CLE credit for this session, please complete the polling question by entering the code that was just announced. The polling question will remain open briefly. For those seeking Kansas, New York, and New Jersey CLE credit, in addition to the polling question, you will need to complete the attorney affirmation form and return it immediately following the program. A copy of the form can be found in the resource list widget. As a reminder, certificates of attendance will be distributed to eligible participants approximately 8 weeks after the web conference via email. The code is not necessary for HRCI credit. A record of your full attendance is all we need to apply for HRCI credit. Okay, so now I'm going to talk to you about payroll problems, specifically about mismatched coverage and payroll deduction periods, and what you can do during a new employee enrollment to help down the road when that person terminates. Unfortunately, oftentimes employees are on automatic payroll deduction, and the period covered by the deduction doesn't match up with the last period of coverage. For example, let's say your plan terminates coverage on an employee's date of termination, but the payroll deduction took out his contribution for the entire month. So really, he's already paid for that whole month, but he's only going to get partial month coverage. Or if the payroll deductions are taken out after the end of the coverage period, for example, employees pay for April coverage in May, then they still owe you money for their previous coverage when they terminate. You need to make it clear in both your SPD and your employee's initial payroll deduction consent form that any employee contributions for coverage that are paid in advance are non-refundable, even if coverage terminates prior to the end of the month. Also, if contributions for coverage are paid after the end of the month, then make it clear that the money is still owed, even if coverage is terminated before the end of the period. For example, you can use language like, if your contributions for coverage are paid in advance, there will be no refund for contributions, even if your coverage terminates prior to the end of the period for which the contributions were paid. Likewise, if your contributions for coverage are paid after the applicable coverage period, known as payment in arrears, you must still pay the full amount, even if your coverage terminated prior to the end of such coverage period, and any such amount may be taken out of your final paycheck. Language like this in your SPDs and your payroll deduction consent forms will save a lot of headaches when your employee terminates. Since we're talking about terminations, let's talk about COBRA. COBRA is expensive to fund because people who elect COBRA tend to be sicker than the general population. So you may want to use a couple of tactics to get people to not elect COBRA. First of all, you should distribute an election notice as soon as possible after a qualifying event to reduce the length of the COBRA election period. For example, the election notice should be distributed on a person's last day of work. The reason you want to get the election notice out quickly is because people eligible for COBRA have 60 days to elect coverage, but that 60-day period doesn't start running until the latter of the date of the loss of coverage and the date the election notice is furnished. That's why it's so important to get those notices out quickly. For example, in the case of a termination, although you have 30 days to tell the plan administrator, which is you if you're self-funded, and then the plan administrator has 14 days to notify the terminated employee of his COBRA election rights, for a total of 44 days, taking all of that time to give this notice will push the election period past the date it could have otherwise ended. And another reason to reduce the election period is because since COBRA allows retroactive election of coverage, sometimes people get injured or sick during the election period, and so then of course they elect COBRA, and your plan has to pay for the claims that arose during that election period. Another way to get people to not elect COBRA is to get them to enroll in the marketplace instead. There are some things you can do to encourage this. First, double check to make sure your election notices have been updated with the marketplace notice. And you might also want to offset that marketplace notice in a box and in large font. And you can also notify people verbally about the availability of marketplace coverage when they lose coverage under your plan. Okay, so now I'm going to transition into talking specifically about lawsuits. The first and simple thing you can do as a self-funded plan to cut down on the number of lawsuits filed against you is to make sure that everyone knows your plan is not insurance. You need to say in your documents that you're not an insurer and the plan is not an insurance policy. And don't use the word premium in your plan documents. Always say employee share contributions or something similar instead. The use of the word premium is misleading because people will think that they have insurance and therefore the rights under state insurance laws. And you don't want to mislead these people. And also, if you have a non-ERISA plan, for example, if you're a church hospital, a government agency, then this is particularly important because state laws are not preempted with respect to your plan. Another thing you can do to avoid lawsuits is to minimize the time period during which people can sue the plan. On the front end, make it clear that no one can sue you until they've completed your plan's entire internal claims and appeals procedure. You can do this in both your SPD and in the claims denials. These documents should state the requirement that a participant exhaust the plan's administrative remedies before filing a lawsuit. For example, say you may not file a lawsuit in a court of law concerning the plan until you exhaust all administrative remedies available to you under the plan. Another thing you can do is specifically tell people that if they blow an appeal deadline, then they cannot sue. For example, say if you fail to timely file a claim or appeal concerning denied benefits, you cannot file a lawsuit in court, and the plan administrator's determination will be final and binding. Embedding the requirements to exhaust internal remedies and hit plan deadlines in the plan documents stops people from heading to court prematurely as long as the plan doesn't miss any of its response deadlines. And by the way, make sure you're not missing your deadlines. On the back end, you can add language to your SPD and your claims and appeal denial letters, shortening the amount of time a participant has to file a lawsuit. Under ERISA, there's no specific prohibition on truncating the amount of time within which participants must bring their federal claim after exhausting the internal review process. So you can put a time period in your plan document as long as it's reasonable. For example, you can state if you wish to file a lawsuit in a court of law, you must file the lawsuit no later than 1 year following your exhaustion of the applicable claims and appeals procedure. You should put that language in your SPD and also in your denial letters. And although under some state laws, a participant might be able to challenge this or a court might find your time period limitations somehow unreasonable, you should still include this language because you have nothing to lose by doing so and because it gives you one more arrow in your quiver. Now, if you do get sued, let's talk about provisions you can put in your plan to improve your chances of a good outcome. Benefits denials will be reviewed de novo unless the plan documents say otherwise. De novo means the court gets to decide the case without deference to the plan administrator's decision. You need to make sure your plan documents clearly state that the plan administrator has the discretionary authority to make benefit determinations. By preserving the right of the plan administrator to use its discretion in making benefit determinations, you also change the standard of review in court from de novo to abuse of discretion. Therefore, instead of the court using its own judgment to decide whether the determination was correct when deciding whether to hold for the plaintiff, the court instead has to determine that the plan administrator abused its discretion or made the decision in an arbitrary and capricious manner before the court can hold for the plaintiff. This is a good thing for the plan. So you want to make sure your SPD specifically says that the plan administrator has the full discretionary authority to administer and interpret the plan, determine eligibility for and the amount of benefits, determine the status and rights of participants, make rulings and factual determinations, make regulations and prescribe procedures, gather, use, and disclose needed information, exercise all power and authority contemplated by ERISA, the Internal Revenue Code, and all other laws with respect to the plan, employ or appoint people to help or advise in any administrative functions such as claims administrators and service providers, and to generally perform any necessary functions to operate, manage, and administer the plan. Finally, you should include a statement that benefits under the plan will only be paid if the plan administrator or the people it delegates decide in their discretion that an individual is entitled to the benefits. Finally, since we're talking about lawsuits, I want to take a moment to discuss protecting the plan in the event of a lawsuit between a participant and a third party. Sometimes you may have a participant who receives medical treatment from your plan for injuries sustained in an accident or some other at-fault situation. The SPD needs to make it clear that in exchange for receipt of benefits from the plan, the participant agrees that the plan has the right to be made whole from any settlement or judgment and also has the right to pursue such a settlement or judgment. The SPD language should include a number of points. First and foremost, that the participant will notify the plan if there's a liable third party and that the participant will reimburse the plan for the benefits the plan paid due to injuries inflicted by the third party after the third party pays. Basically, make it clear that the participant has to pay you if he recovers a settlement for injuries that you paid to treat. But sometimes things don't go smoothly in that respect, so get the participant to also agree to allow the plan to offset future benefit payments to the participant based on money received by the participant from the third party. In other words, make it clear that you will stop paying benefits for future medical bills of the participant until the plan is made whole. Also, you should include some language to try to avoid application of cases that require settlement amounts to be traced in order for the plan to get a lien on the settlement funds. This will hopefully allow you to pursue commingled assets. And also, you want to deal with the fact that the participant might spend a lot of money on attorney's fees, which eats into the settlement amount. You can handle this by specifically stating that there's no obligation that the participant be made whole. Okay, so that's the end of my talk, and I hope that these strategies will help you avoid some headaches. If you have any questions regarding today's presentation, please submit them in the Q&A widget, and a member of Foley and Lardner's Employee Benefits and Executive Compensation Practice Group will follow up with you. At the conclusion of this program, a questionnaire is going to appear. Please take a minute or two to give us your feedback about the presentation today. It's really important to us to know your thoughts, and it helps us shape our programs going forward. If you have any CLE questions, please contact Harrison Papadakis at his email address, which is in the slide here, hpapadakis@foley.com. Certificates of attendance will be distributed to eligible participants approximately 8 weeks after the web conference via email. Thank you so much for attending. We really appreciate it. Take care.